Good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Laterios Bates, verified in Smith County. We'll recall that case. Bryce Carroll. Bryce Christopher Carroll. Kaylin Cheatham. Kaylin Cheatham.
He called and said he'd be about 30 minutes late.
All right, thanks. Robert Glass is verified in TDC custody in the Bradshaw unit. We'll recall that case. Matthew Gould. Here. Kirkland Huggins. Jennifer Jacobs. She's outside, I believe, in the hallway. Jordan Manning. Guy McSpadden. Matthew Powell. Cedric Thompson has already made an appearance. I'll recall that case. Wayne Wingo. Mark Witherspoon. Mark Daniel Witherspoon. Jalen Young. Jalen Fairley. Christopher Carroll. Christopher Yates. Marissa Coleman. Sean Nunez. Damian Wylaz. Here. Cedric Thompson.
You didn't call his name, Your Honor.
David Carley. Here. Mr. Thorson is going to be appearing via Zoom today. He's present. Robert Jordan. I'm sorry. Bobby Eugene Jordan.
He's present, counsel, Judge.
Thank you, Mr. White. Karen Kirby.
Same now, Judge.
Arella Gilchrist. Deal Shpati.
Here.
Rodana Tacker. All right, is there anyone in the courtroom your name's not been called? All right, Mr. Shpati, Mr. White, you have
That's why he said.
This is cause number CR 25-136, State versus DL Shpati. Mr. White, I believe we're set for pretrial today. Go ahead.
Your Honor, we don't have any contested pretrial at this time. We'd ask the court to move this over to docket call. I know the court has maybe a December 2nd and 4th, but I am currently set on December 1st in Kaufman County for a jury trial. That would probably last. We have to have a jury trial. It's going to last that week, probably.
December 16th?
Yes, sir.
All right, court sets Mr. Shpati for docket call December 16th at 9 a.m. Once he signs, he's free to go. No.
Your Honor. That's something to take go.
Yes, I was going to call her case. All right. State versus Cedric Earl Thompson, CR 25-19. All right. We were set for pretrial today. The court has excused Mr. Thompson's presence today. He's made an appearance this morning and signed a notice of appearance. Any announcements from the defense?
Your Honor, we have requested that this case be set for a plea that would resolve all three of Mr. Thompson's cases. They've already been scheduled for December 2nd at 1:30. And I've talked with Mr. Hernandez about these cases, and basically the plan is that since I've only made my appearance on the one case, I would basically serve in essence as standby counsel on the other two. And all three would be for 10 years TDC to run CC.
Is your client going to be representing himself, or are those cases being 1245? Because if you're going to be standby counsel, I'm going to have to admonish him of what it means to be self-represented, and you're obviously not going to be explaining his rights to him with regards to those two cases. So I would have to make sure that he has the.
As standby counsel, I would advise him of his rights, and since I do have the one retained case, I would, just like I do with any of my clients, be explaining the full paperwork to him. So, and it's
I
gonna,
would still have to admonish him. then.
yes.
State, what's your opinion on that? Are you comfortable with that?
We are, Your Honor. Actually, discovery has been provided to Ms. Fallhaber already, so she has discovery on all three cases. So she is well versed on all of the information, and in order for us to reach a plea disposition on the case that she has entered on, she had to review the other two cases. It's a concurrent sentence. It's 10 years on all three cases. So it would just be a plea to the indicted charge on each case.
So during that plea process, you would not be emailing plea paperwork or judgments to her, so she wouldn't be able to review that unless you just sent it to her, because her name shouldn't appear on any of that if she's
It-
not.
That's correct. It would not. I can certainly just have our legal assistant print out that paperwork if you'd like. And we can have Mr. Thompson actually review hard copies here in court prior to tendering his plea to the court.
Well, I still like to have it electronic. I'm just saying it would need to be emailed to Mr. Thompson. Someone's gonna have to walk him through that process.
I mean, it's not a problem to email it to Mr. Thompson. I can provide his email address, but I also, since he is a current client and since I will in a sense be acting as standby counsel, I also don't mind receiving it and then getting him to sign it.
All right, go ahead and bring an extra hard copy that day, just in case.
Okay.
Let's plan for that. All right, court will set, you said December 2nd, correct?
Yes, Your Honor.
All right, court sets Mr. Thompson in all three cases December 2nd for plea before the court at 1:30.
Thank you. May I be excused?
Yes.
Thank you.
All right, we have any other counsels ready? Mr. White, you ready? Who would you like to call?
Ms. Tacker.
Radonna Attacker, CR 25-137, CR 25-150. We're set for docket call in each.
Your Honor, the state and I are still trying to work this one out. I believe if we could set it for December 16th for a final, we will either plea or dismiss it or whatever on that date. Or set it for trial.
Any objections from the state?
No, Your Honor. Thank you.
All right, court sets Ms. Tacker for final docket call December 16th at 9 a.m. in each case. We have Ms. Gilchrist.
Yes, sir.
Ms. Gilchrist, CR 25-200. And ma'am, how do you say your first name? Is it Ariella?
Ariella, yes.
Ariella. Okay. All right, Mr. White, any announcements? I think we're set for arraignment.
Yes, sir. I have filed a motion to withdraw on this case, Your Honor. It should be with the court. I have a conflict of interest, and I've informed Ms. Gilchrist of that. And once I found out that I believed I had a conflict of interest, I contacted the State Bar Ethics. They confirmed that I did in fact have one. And so I informed them that I needed to withdraw.
Ms. Gilchrist?
Your Honor, I respectfully challenge the claim that my attorney has multiple conflicts of
Hang on,
interest.
whoa. You're going way too fast, because one, I gotta hear you, two, she's gotta type it
Oh,
down.
I'm sorry.
So just take a breath.
Yes, sir.
You're not in a rush.
I understand
All
that.
right, go ahead.
I respectfully challenge the claim that my attorney stated out there that he has multiple conflicts of interest, not just one, and I request that the court require my attorney to clearly identify who these alleged conflicts involve, what their connection is to me or this case, and how these conflicts prevent the ethical representation. I believe and have proof that at least one of these individuals have participated in the setup against me, And I need full transparency to protect my rights and ensure a fair defense.
Go ahead, Mr. White.
I didn't want her to say something that in front of the court that could hurt her. But I do have a conflict and it's unavoidable.
What is your position on her wanting you to state what your conflicts are?
I mean, of course, if the court orders me to, I will ask, that I be able to do it in chambers, ex parte, because of the nature of what I think it is, because I can't state it. When I talked to the ethics folks, they said I was governed by Rule 105, and they said that I owe a duty of confidentiality to present, prospective, or past clients.
And have you disclosed these conflicts to your client?
They had advised that because of the nature of the conflict that I should just say I have a conflict.
All right, well, we'll recall this case and then we'll meet in chambers and we'll get together to figure out how best to proceed. Yes, sir. Is it Pointer?
Yes, sure.
Mr. Pointer,
Yeah, Pointer.
are you ready on Mr. Yates?
Yes, sir.
Christopher Matthew Yates. Cause numbers CR 25-222 and CR 25-223. Mr. Yates is set for arraignment in each case. Mr. Pointer, have you had an opportunity to go over the indictments with your client?
Yes, sir. And at this time, defendant waives formal arraignment. Discovery has been open to us, but just yesterday we had problems opening it. So we're just asking for the reset so that we can,
Is his name spelled correctly in the indictment?
it is correctly.
He understands what he's charged with.
Yes, sir.
He understands the range of punishment.
Yes, sir.
All right, court finds that the defendant has waived the formal requirements of arraignment. Court will set this matter for pretrial hearing. Mr. Pointer, are you available on December 2nd or 4th?
I'm available on the 2nd.
Second? All right, court sets Mr. Yates then for pretrial December 2nd at 9 a.m. So, Mr. Pointer, I would just ask that you get with the state, make sure that you'll work out the discovery, delivery, the electronic discovery. And then if there are any contested motions prior to the 2nd, you need to file those at least 7 days prior to. We won't hear the contested motions on that day. It will just be the deadline for filing. And if there is a request for contested, we'll set another date on December 2nd so we can all prepare. It'll be on evidentiary docket. Court has time to hear arguments and needing testimony.
All right. Thank you, Your Honor.
You're welcome. And once he signs his notice of appearance, he's free to go.
May we be excused?
Yes. Sir. All right, for the record, cause number CR 25-180, State versus Laterios Untrey Bates, which is set for arraignment today on second-degree possession of controlled substance. Mr. Bates has been verified in custody in Smith County. Appears that Mr. Bates is being held on a manufactured delivery of a controlled substance, tampering, physical evidence, assault of a peace officer, assisting search and transport, and evading arrest or detention. Board is going to reset this case to January 6th for status. We'll see how his charges go in Smith County. Cause number CR 25-201, State versus Robert Wayne Glass. Mr. Glass is set for arraignment today on a first-degree felony offense of aggravated sexual assault of a child. Mr. Glass is verified in custody in Texas Department of Criminal Justice Bradshaw Unit. It appears that Mr. Glass received sentences out of Anderson County in October of 2023. 10 years, and then out of this county in February of 2024 for 4 years. So a request by the state for a bench warrant.
There is, Your Honor. Thank you.
Board will reset Mr. Glass Tuesday, January 6th for arraignment. David Ray Carly, you come on up. Good morning, Mr. Thorson. Can you see and hear me okay?
Yes, sir.
All right, court call CR 24-179, State of Texas versus David Ray Carly. Mr. Carly is present in the courtroom. Mr. Thorson, counsel for Mr. Carly, is appearing via Zoom. Mr. Thorson, we are set for pretrial today. Any announcements?
Judge, we've received discovery and reviewed it. We don't have a plea offer. Mr. Hartswell and I have been discussing it. I hope that we can explore resolving it. At this time, I guess if we could have another pretrial setting, I've been kind of busy with some other matters, or if we want to get a trial setting, I would just ask that it's after the first of the year based on kind of some other trial schedules I have between here and there. So,
Do you anticipate any contested pretrial motions?
no, sir, not at this time.
All right, have you received all your discovery?
I believe so, yes.
All right, then what I would do, I would just set it for docket call in December. And then if the
Okay.
state's going to make an offer, that gives them time. If they're not going to make an offer, then we'll set it for jury trial or bench trial at the defendant's request.
Thank you, Judge.
All right,
I appreciate that.
Are you available December 2nd or 4th?
Let's do the 4th.
All right, court sets Mr. Carly then for docket call December 4th at 9 a.m. I'm gonna have your client sign a notice of appearance with that date on there, give him a copy, and then he'll be free to go.
Thank you, Judge. Thank you for accommodating me again this morning on
Yeah.
schedule. So,
You're welcome.
all right.
See you
See
later
you
this
soon.
week.
All right. Bye.
Mr. Carly, when you leave today, I want you to go across to the pretrial release department and check in over there at, you know where the pretrial release department is?
officer?
Yes.
Yeah.
Yeah, check in with him and then you'll be free to go.
I have an appointment.
Okay, good.
No big excuse.
Yes, sir, you're free to go. Mr. Schmidt, are you ready on anyone or do you need time?
Yeah.
Who'd you like to call first? Mr. Nunez. CR 25-184. Mr. Nunez is set for pretrial.
That's correct, Judge. We don't have any contested pretrial. We'd ask to set him for a plea in December.
Morning or afternoon?
Morning, please.
All right, court sets Mr. Nunez for plea before the court December 2nd, 9 a.m.
Marissa Coleman.
Ms. Coleman? This is cause number CR 25-35, State of Texas versus Carissa Bernice Coleman, set for docket call, final docket call. Go ahead, Mr. Schmidt.
That's correct, Judge. We'd ask to set her for a plea. And Judge, she's coming from Detroit, right?
Yes.
From Detroit. It'll be an afternoon plea. We'd ask the court for a little bit more time than that December 2nd.
December 16th.
Later if you could, but if that's as
State.
far.
No objection, Your Honor.
I'm getting the feeling it's either before Christmas or after Christmas. Are you
Well-
asking for after Christmas?
She'd like
Are you
that.
asking for after Christmas?
Yes, sir, if that's
State,
possible.
objection.
No objection, Your Honor.
All right. January 6th, 1:30.
Thank you, sir. She's not gonna come. That's right next to my office. It's there. Hold on, she got on email, though. Sure. It'll be all right.
Thank you, John.
You're welcome.
Jalen Young.
This is cause number CR 25-224, State versus Jalen D. Young for arraignment. Go ahead.
Judge, I was appointed to represent Mr. Young this morning. Received a copy of the indictment. We went over that. His name spelled correctly. We'd waive formal reading in our plea. We'll be asked for a pretrial date.
All right, court finding that Mr. Young, having waived the formal requirements of arraignment, sets this matter for pretrial. You want that, you want the December 2nd?
That'll be fine, Judge.
All right, court sets Mr. Young for pretrial December 2nd at 9 a.m.
So.
Yes. Who's next, Mr. Smith?
Jennifer Jacobs.
Ms. Jacobs? This is cause number CR 24-235, State versus Jennifer Lynn Jacobs. Ms. Jacobs is set for arraignment.
That's correct, Judge. Same announcement, received a copy of the indictments, name spelled correctly. Wade reading enter a plea of not guilty. That's the plea trial.
All right, court finding that Ms. Jacobs has waived the formal requirements of arraignment, enters her plea of not guilty into the record, and will set this matter for pretrial hearing December 2nd. 9 a.m.
West, the pretrial is. Okay, I think she needs to meet with Mr. West. You want her back there or out in the hall? Right, go out. Damian Wilatz.
Mr. Wiles? This is cause number CR 25-174, State versus Damian Alexander Wiles. Mr. Wiles is set for docket call. I see that the state has filed a motion to dismiss the case, citing insufficient evidence. Any objection from the defense?
No objection.
All right, the court, having reviewed the motion, hereby grants the state's motion to dismiss. Mr. Wiles, you're free to go.
And Judge, is it possible to get a copy of that signed order?
It's going to be done through e-file.
That'll be
So
fine. I'll
Yeah.
just email it I'll email him a copy. Okay. You're free.
I just signed it and sent it to him. So. Mr. Weiner?
Yes, Your Honor.
You ready? Bobby Eugene Jordan. CR 25-80. Mr. Jordan set for pretrial. Go ahead.
Yes, Your Honor, we don't have any pretrial at this time. I think we're ready for a docket call.
Right. You want December 2nd or 4th?
The second would be great, Judge.
All right, court sets Mr. Jordan then for docket call December 2nd at 9 a.m. Once he signs his notice, he's free to go.
I'll have him copy.
Please do. Yeah, sign right there. And I'll get the prosecutor sign. I'll get you a copy. Okay. Oh, good.
Kirby? It's cause number CR 25-49, State versus Karen Marie Kirby. We're set for a plea today, I believe. Ms.
Yes, Your Honor.
Kirby, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you, ma'am. You can lower your hand. During your plea, just speak up loudly and clearly so I can hear you, okay?
Yes, sir.
All right, your name is Karen Marie Kirby, is that correct?
Yes.
And Ms. Kirby, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Justin Weiner. Are you pleased with the work that Mr. Weiner's done for you as your attorney?
Yes.
Do you have any questions about any of the plea papers that you've read over and signed today?
No, Your Honor.
Mr. Weiner, do you believe your client to be competent? And if so, do you believe that she's entering into this agreement intentionally, knowingly, and voluntarily after having been informed of her legal rights?
Yes to all that, Judge.
All right, good. All right, Ms. Kirby, I see here that you are charged with a offensive manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 400 grams, that being a first-degree felony. It does carry a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice if you were to be convicted and sentenced. You could also receive a fine up to $10,000. Do you understand that full range of punishment?
Yes, Your Honor.
I see that there is a plea agreement in your case wherein upon you pleading guilty, the state's recommending to the court that the court consider the evidence but defer a finding of guilt, meaning the court would consider the evidence today but would not convict you of the offense. Rather, you would be placed on community supervision for a period of 10 years. And during that period of community supervision, you would also be ordered to pay a fine of $2,000, restitution of $180, court costs of $290, reimbursement fees of $55. And as part of the plea agreement, the state is recommending that the following unfiled cases be rejected for prosecution. Another manufacture, delivery of controlled substance, and a possession of a controlled substance and also a possession of marijuana. Ms. Kirby, is that your understanding of the plea agreement?
Yes, sir.
And Mr. Weiner, I didn't ask this specifically, but you did explain to your client the advantages and disadvantages of a deferred adjudication plea.
I explained certainly the advantages, but also the significant hammer it's going to be over her head the next 10 years.
All right. Ms. Kirby, the court having explained to you the range of punishment and the plea agreement, I would ask you at this time, how do you plead to manufacture or delivery of a controlled substance, a penalty group 1, greater than or equal to 400 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No.
Court does accept the defendant's plea of guilt. Mr. Weiner, any objection to the admission of the stipulation of evidence?
We have no objection, Judge.
Right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank
Anything
you.
further from defense?
No, Your Honor.
All right, court's going to review the evidence. All right, the court having reviewed the evidence finds there is enough evidence to convict the defendant of the offense. Court will follow the plea agreement today. The court defers a finding of guilt, places the defendant on 10 years community supervision, orders her to pay a $2,000 fine, restitution of $180, court costs of $290, and reimbursement fees of $55. Further, the court does find that the state is rejecting and is barred from prosecuting unfiled DA cause number 2024-849, manufacture delivery of controlled substance, DA 2024-850, possession of a controlled substance, third degree, and also DA 2024-851, possession of marijuana between 4 ounces and 5 pounds. Ms. Kirby, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that, you'll meet with the probation officers over here.
Caller, can anything?
Is that all you have, Mr. Weiner?
That is, Judge. May I be excused?
Yes, sir.
Thank
Thank you.
you.
Good to see you.
It's great seeing you, Judge.
Matthew Powell. Oh, yes. Is Mark Witherspoon here? Mark Witherspoon? Court's gonna stand in recess for about 20 minutes to meet with Mr. White in chambers in the state. And so it's about 10 till, so everyone in the courtroom check back in about 10 after 10. All right, court's in recess. Ms. Gilchrist. Cause number CR 25-200. All right, the court has met with Mr. White, counsel for Ms. Gilchrist in chambers ex parte states consent regarding the conflict of interest as alleged in the defense counsel's motion to withdraw. The court finds that Mr. Nolan White does have a legal conflict that prevents him from continuing representation of Ms. Gilchrist. So Ms. Gilchrist, at this time, you're set for arraignment. What the court can do based on what your response is I can either reset the arraignment today and give you time to get new counsel that doesn't have a conflict that can represent you. Or if you cannot afford an attorney, then the court could consider your indigency status upon your application for court-appointed attorney. What would you like to do at this time? Would you like to have the court reset it so that you can get counsel of your own choosing, if you can afford it? Or are you asking the court to appoint you an attorney because you cannot afford one?
I do have one concern, Your Honor.
What is that?
Um,
And listen, let me tell you, because I think Mr. White's already counseled you on this, but I don't want you to say anything that could compromise your case, anything that could incriminate you,
I
or
understand.
anything that could be used against you, because we do have the prosecution here in the courtroom and we are on the open
I
record.
understand. Yes, sir.
Go ahead.
One thing that does concern me is that I have had no information about anything in regards to the discovery. I found out about the discovery at the same time in which he told me he was revoking himself as my lawyer. That is a concern to me. As in regards to your question, I plan to hire a lawyer if the court-appointed lawyer doesn't suffice to what I need for this case. It is a very complicated case.
Okay, well, it's not you don't get to choose a court-appointed attorney, and then if you're not happy with them, then you hire an attorney. It's on the basis of your financial ability. If you are financially able to employ an attorney, then you're going to be prohibited from getting a court-appointed attorney.
I understand that. My apologies. I should have explained further. So I myself cannot afford a lawyer, and I do qualify for indigency lawyer. Because I signed it when I was in jail. I filled it out and then they had one appointed to me. However, my mother said that there would be a chance that she could possibly help in the future if this plays out a certain way. We just have to see how it plays out. So for now, a court appointed one is the one I would like to go for in the future. If that doesn't work out, I would be motioning to get one to hire if I am able to financially.
All right, then what I'll have to review that. I know you say that you're eligible. I've got to make that decision. So I have to review that to see if you meet the poverty level that's provided by statute. Okay. So what I'll do is I'll recall your case in just a moment. Mr. White, I am granting your motion to withdraw as counsel today.
Yes, sir.
Right.
Have excuse, sir.
However,
Excuse, thank you.
the discovery issue,
When you get a court-appointed attorney or you hire an attorney, then that attorney will be able to get the discovery for you.
yes, sir.
Okay, so have a seat and let me review your application. Have you turned that in to Ms. Tabor?
I have it right here.
Okay.
I got it.
If you haven't finished it, then finish it. Mr. Schmidt, ready, everything you want? Mr. Powell?
Yeah. Partly.
This is cause number CR 24-219, State of Texas versus Matthew Lee Powell. Here on a motion to adjudicate or to revoke filed by the state. Court has found Mr. Powell to be indigent for purposes of the Sixth Amendment. Court has appointed the Honorable Richard Schmidt as counsel. Today, Mr. Schmidt, I will reset today's case. We will move it over to the tested docket, which will be December 16th. That'll be the you are still on vision. You're still required to follow all terms and conditions of the court. Yes, sir. Good morning, sir. Here you are. All right, this is cause number CR 25-199, State versus Jalen Jamal Fairley or Farley. And we're set for arraignment today. Have you had a chance to go over the indictment with your client?
Yes, Judge, I've with the, yes.
All right, do you waive the formal requirements of arraignment?
Yes, Judge, we'll wait for my reading.
Is his name spelled correctly?
Yes, it is, Judge.
And he understands what he's charged with and the range of punishment?
That is correct.
All right, the court finds that, is it Farley or Fairley?
Fairly.
Fairley. Court finds that Mr. Fairley, having waived the formal requirements of arraignment, enters his plea of not guilty into the record, and the court will set this matter for pretrial hearing. Mr. Carpenter, if you have your calendar available, are you available December 2nd or 4th?
December 2nd should work, Judge.
2nd? All right, Mr. Fairley, court is setting you for pretrial hearing December 2nd at 9 a.m. And Mr. Carpenter, do you have a notice of appearance form there?
I will make sure I get that. I think the court told me I needed to, I thought I'd already e-filed one, but I'll make sure I do that for you.
Yeah, well, just come up here. There's one
Oh,
here.
oh, we got a black one.
Basket. And I'm gonna have you and your client sign that.
Okay,
You'll get the gold copy, yellow copy, and then you'll leave the white one here for the court.
okay. Thank you, Judge.
Christopher Carroll. Mr. Hawkins is gonna be appearing via Zoom. Good morning, Mr. Hawkins. Can you see and hear me okay?
Yes, sir.
All right, good morning. This is cause number CR 25-143 and 144, State of Texas versus Christopher Roy Carroll. Mr. Carroll is present in the courtroom. Mr. Hawkins is appearing via Zoom. And Mr. Carroll is set for pretrial today. Mr. Hawkins.
That's correct, Your Honor. And Your Honor, my understanding, there's still some outstanding discovery in this case. There's a, here's a co-defendant that I guess that announcement was made the last time in court that there was additional discovery to be had. I'm not aware of what that is exactly, but my understanding that there is additional discovery that has not been produced.
State.
I'm not aware of that, Your Honor. I welcome a phone call.
And it may be my misunderstanding, Your Honor. I just know that on the accompanying case, that was what was stated, that there was additional discovery that was outstanding. And if there's not, then Your Honor, then I don't have any pretrials for today, and we just ask for another setting.
Who is the, you said accompanying case? Are you talking about a co-defendant?
Co-defendant, yes, Judge.
Do you know who the co-defendant is?
And it may have been my misunderstanding, Your Honor, but I just know that there was a hearing on the last time on hers, and that was what was discussed, I guess, to the court. And so I was unaware of it until I heard that. And so if it's not applying to my case and I have everything, then I'm comfortable with that.
Who is the co-defendant?
Judge, I don't know her name off the top of my head.
State, do you know?
Your Honor, not off the top of my head, and I can't get LGS to cooperate with me right now.
Carol, what's the name of your co-defendant?
Jody Denton.
Jody?
Jody Denton.
Jody Denton. Thank you, Mr. Carroll. Jody Denton. You said that you're not able to get into LGS, Mr. Hartwell?
Yes, sir. It won't let me to log into the prosecutor side at all.
All right, so what we'll do, Mr. Hawkins, I will go ahead and move you over to docket call. Should there be additional discovery provided by the state that causes a need for you to file a pretrial motion, then the court will grant you leave to do so.
Yes, sir.
So are you available December 2nd or December 4th for docket call?
I'm good for December the 2nd, Your Honor.
December 2nd. All right, court sets
Yes, Your
Mr.
Honor.
Carroll then for docket call in each case, December 2nd at 9 a.m.
Yes, Your Honor.
Mr. Hawkins.
Thank you, Judge. I appreciate you.
Hey, you're welcome. We're going to have your client sign a notice of appearance and he's free to go.
Okay, thank you, Judge. Y'all have a good day.
You're welcome. You as well.
All right, bye-bye.
Wayne Wingo. All right, Mr. Wingo, this is a sanctions court hearing, CR 24-67. All right, Mr. Wingo, I believe the last time we were in sanctions court, I ordered you to do a few things. One of them was to work 20 hours community service.
Yes.
I have record that you did that, ordered you to pay 130 to the probation department for fees. I find that you complied with that. I have a note here that says that you've not provided any medical documentation.
I gave it to Stephanie Newborn
When did you do that?
right after court when I went and reported. She made copies of it.
That was after our last court date.
Yes, sir.
All right, so what I'll do, Mr. Wingo, is I'm gonna reset you for December 2nd. I'm order you to do $65 to probation. 20 hours community service. Where did you do your last set of community service?
Canton First Monday, that's what I always schedule with my work. That's when I'm able to get it done.
Are you getting the full 50 or are you just getting some?
I'm only able to get Saturday and Sunday off of work, so I get 20 each month.
All right. And then I will check with the probation department on the medical stuff. If they need additional, then they'll reach out and ask you for that, okay?
Yes, sir.
All right, we'll have you come back on December 2nd. I have 20 hours community service and $65 to probation. Jordan Manning. This is a sanctions court hearing. All right, Mr. Manning, the last time you were in sanctions court, we talked about a few things. I ordered you to do 15 hours community service, $75 towards your probation fees, and $50 towards your clerk fees. Now, my records say that you didn't do any of those things.
I have receipts for my fees. I did not complete my community service, Your Honor.
When did you pay your fees?
Yesterday,
How much did you pay towards your probation fees?
75,
How much did you pay towards your clerk fees?
50.
You did that yesterday?
Yes, sir.
Why did you not do the community service?
Me and my family was sick with COVID, and my car had broke down. And the place that I was doing community service recently shut down due to a tragedy with the family, and apparently they're reopening in November.
You know, there's other places to do community service.
Yes, sir. I've been having trouble with the charge that I do have. It's an aggravated charge, so a lot of places around here won't accept me to. They don't feel comfortable, I guess, with the aggravated assault. So
Yeah, that's understandable. You're gonna experience that probably the rest of your life. What about, are you working?
Yes, sir.
Where are you working at?
R&R construction.
All right, so what I'm gonna do, Mr. Manning, is I'm gonna order you to come back on December 2nd. $5 towards your probation fees. $50 towards your clerk fees. So what I'm gonna do is if you do not do your community service, that's gonna be a day in jail.
Yes, sir.
Okay, and so when you get out of jail, you still have to do it. So it's not like you get to trade jail time for community service.
Sir, I understand.
Make sense? All right, so you'll get 1 day in jail if you do not do your community service. Okay?
Sir.
All right, I'll have you come back on December 2nd. We're gonna have you sign this notice of appearance.
Is that correct?
Mr. Huggins. This is cause number CR 20-125, State versus Kirkland Wade Huggins, Sanctions Court. All right, Mr. Huggins. Last sanctions court, we talked about community service to work 10 hours. Complied with that. The note said that you complied with your counseling order. It says that you failed to comply with probation and collection. I'm assuming you've gotten those paid.
Yes, sir. I got them paid yesterday. I was having a little bit of financial problems, but I did get them paid yesterday.
Okay. How much did you pay towards probation?
$65, and then to my court costs, I paid 40.
All right, so we're gonna come back on December 2nd. I want you to do those same things, okay?
Yes, sir.
65 to probation, 40 to court collections, 10 hours community service, and continue your counseling.
Yes, sir.
I'm gonna have you sign this notice of appearance and it'll be good to go.
Yes, sir. Thank you, Your Honor.
You're welcome. Mr. McSpadden? All right, Mr. McSpadden, let's see. Did you pay your probation fees?
Yes, sir. I paid 50 for each. Only reason I paid the full amount, being a disabled vet, the government's locked down and I haven't got received any payments,
When did you pay 50?
this morning to each.
What about your community service?
Yes, sir. 20 hours.
When and where did you do that?
The Helping Hands in Hawkins.
And when did you do it?
Let's see. The first, the second, the 7th, 8th, and 9th.
You have documentation of that?
Yes, sir.
All right, did you turn that into your probation worker?
I tried to turn it in this morning. I was told to hold on to it.
Tell me your issue with the VA and why you can't pay.
Because that's I'm on disability through the VA and the government's locked down, so they haven't issued any payments.
When's the last time you got a VA payment?
last month.
When do you expect your next one?
Hopefully anytime, Your Honor.
I'm gonna have you come back on December 2nd, $100 towards. Actually, we're gonna have to do 150 for probation.
Okay.
We're gonna have to do 110 for collections,
Yes, sir.
20 hours community service.
Yes, sir.
That's just to get you caught up.
Yes, sir. Thank you, Your Honor.
You're welcome. Cheatham. Mr. Cheatham, you are consistently late to court. Are you consistently late to work?
No, sir.
Why do you show up to work on time, but you don't show up to court on time?
I haven't been late in a minute. It's been a little while since I've been late.
You're late today
Yeah, I was late today.
by an hour or more.
It was like 20 minutes, I think. I had to drop my daughter off at daycare though. They opened up at 8.
But you might, on court days, you might want to get someone else to drop off your daughter so you can get here on time. Okay,
I definitely would have if I had somebody to do it.
I'm saying you're going to have to find somebody. You're going to figure it out. You're in that part of life where you need to figure things out, or things are going to be figured out for you, and you're not going to like the way that things are figured out for you.
So,
Did you pay your $150 to probation?
yes, sir.
When'd you pay that?
Oh, not the probation. They don't take cash, but I paid the court costs.
When did you pay court costs?
This morning.
This morning?
Yes, sir.
How much?
It was the 100 that was on the paper.
When are you going to pay your 152? Do you have $150 cash on you?
I have 100 cash on me.
You have 100? You're supposed to pay 150 though.
I get paid on Friday. I had to buy tires for my car, so that was like 380, and that's what really set me back for real.
What about your community service?
And I got it all.
When and where? Because it says on here you didn't do it.
It's the B. I got the paper. I just got to go over to turn it in. So,
When and where did you do it?
it was at the Beaver Institute of Science and Technology.
And when did you do it?
The 2nd, 6th, 7th, 16th, the 20th, the 24th, and 26th.
How many hours did you do?
On the 2nd, it was 4 to 7, so that was 3. On the 6th, it was 3:30 to 8:30. It was 5. The 7th, 4:15 to 7:15, 3. The 9th, 3:30 to 6:30, 3. The 16th, 12 p.m. to 4:30 p.m., 4.5. The 20th, 3:30 to 7, 3. Well, wait. Wait, 3. Yeah, 4. And the 22nd, 2 to 4, that was 2. The 24th, 4 to 8, that was 4. And the 27th was 4 to 6.
What is that, 30 minutes short? 29.5. Is that right? I got 3 and 5 is 8 plus, let's see, that's 8, and then you got 3 is 11 plus 3 is 14 plus 4.5, 18 plus 3, 21.5 plus 2, 23.5 plus 4, 27.5 plus 2, 29.5. All right.
Sir.
All right, so I'm gonna have you, so I'm gonna have you do on December 2nd, I'm gonna have you do another 30 hours community service. $150 to probation. $100 to court collections. And I need that 150 that you owe. Need that. How much do you have today? 100?
100 in cash. Yes,
All right, I want you to go figure out how to get it in a cashier's check or however probation wants it. I want that paid today before you, the other 50 paid on Friday. All right, or I say by Monday of next week.
sir. Yeah, I have it on Friday. I put that right on mine.
Well, but they're only gonna be open till noon on Friday, so depending on when you get that, I'll give you till Monday.
Okay.
But I want that paid. If you miss any of that, then we'll have a different conversation on the 2nd. I want you here on time. Okay,
Yes,
here
sir.
on time at 9 o'clock when I call your name. I want here. I don't want he's 20 minutes out. He's 30 minutes out. I want you here at 9 o'clock. Okay,
Yes, sir.
it's
Got
important.
my word.
It's important. I've got to see that you're taking this serious.
Thank you.
You're welcome. It's Carol's time.
I got it.
Let's go, Chris, come on up. All right, this is cause number CR 25-200. State of Texas versus Ariella Fallon Gilchrist. Court finds that Ms. Gilchrist was set for arraignment today. The court previously entertained Mr. Nolan White's motion to withdraw as counsel. The court has granted that motion to withdraw based on legal conflict of interest. Court had also reviewed and approved Ms. Gilchrist's request for court-appointed counsel, finds her to be indigent at this time. The court has appointed the Honorable Richard Schmidt as counsel. Mr. Schmidt, will be an opportunity to be fine over. Are you ready for me?
I have, Judge, and we're ready to proceed with the ring.
All right, you may proceed.
She understands the nature of the charges. Her name is spelled out correctly in the indictment. We'll waive formal reading or a plea of not guilty. And Judge, I'd ask for a pretrial setting a little bit later than that, December 2nd. The second group in December is fine, but.
All right, the court finds that Ms. Gilchrist, having waived formal requirements of arraignment, certificate of not guilty record. Court says Ms. Gilchrist for pretrial, you want, got it, December 16th.
That'll work. Yes, sir.
Court says Ms. Gilchrist for pretrial, December 16th.
Well, reset polls. On that day. You shoot me, but I'm not sure what call within the next week or so, we'll get set up then. Okay, sorry.
Ms. Gilchrist, you understand that as part of your conditions of pretrial release, you're required to pay maintain county reimbursement, and county rate of $50 per month.
Yes.
For appointment.
I am aware of how much I'm delinquent and I'm going to take care of that payment. So,
That's Chris. All right, we'll see you back on.
thank you.
Okay, good.
R. All right, court has ordered Mark Daniel Witherspoon to be present in court today for arraignment. Court finds that Mr. Witherspoon has failed to appear. His name has been called loudly and distinctly 3 times. Courthouse with a response. Court hereby issued judge's homicide conspicuous. Mark Daniel Witherspoon. All right, I believe that completes the court's criminal docket for the morning. Court's going to stand in recess until 1:30.